Yes, good morning, good afternoon to everyone. Welcome to our panel discussion on the key to unblocking Security Council referrals, vetoes, and atrocity crimes, which is being organized by the New York University Center for Global Affairs and co-sponsored by the permanent missions to the United Nations of Costa Rica, Sierra Leone, and the Netherlands, together with the International Center for Transitional Justice, which I represent. Let me first of all thank the government of Costa Rica, Sierra Leone, and the Netherlands for their support to the event and their consistent interest on this issue. Please note that this event is being recorded. Questions after the discussion of the panel can be posted using the Q&A. And if you wish your intervention, comment, or question to be attributed, please indicate so by writing your name and title. I now have the pleasure to introduce His Excellency Ambassador Ali KABBA, Permanent Representative of Sierra Leone to the United Nations, for the introductory remarks. Ambassador, with deep gratitude for the exemplary role that your government is playing on the global issues of accountability, which is once again evident in this session of the ASP, the floor is now yours.
Thank you so much. Excellencies, representatives of state parties, members of civil society, distinguished guests. Sierra Leone is pleased to join Costa Rica and the Kingdom of the Netherlands as co-sponsors of this event, and we are equally pleased to do so together with the International Center for Transitional Justice. It is my honor to warmly welcome you all to this important event and thank you for your attendance. As you know, we are commemorating the 75th anniversary of the United Nations this eventful year. And without doubt, 2020 has been a period of great disruption for our world, compounded by an unprecedented global health crisis with severe economic and social impacts. It will therefore be understandable to focus discussions at the international level on the public health and economic crisis. Our topic today, however, and appropriately so, spotlight one of the enduring challenges faced by the United Nations since inception. And this is the existence and use of the veto. Therefore, and with the disruptions, 2020 must be a year of dialogue when we come together to discuss our priorities on the public health and economic challenges, and also on peace, security, and the protection of human rights. Excellencies, dear guests, Sierra Leone welcomes academic contributions to the work we do at the United Nations and as state parties to the Rome Statute of the International Criminal Court. Often, we are made aware of perspectives beyond the interests of states. Perspectives from civil society, academia, and practitioners, inclusive of eminent panelists here, enrich our debate with interesting insight as food for thought. On this note, while we appreciate the importance of the topic and scope, Sierra Leone, acting in the capacity as chair of the African Union Committee of 10, with mandate to advocate and canvass the African Common Position on United Nations Security Council reform, it is mindful that we work to make sure that we don't endorse a piecemeal approach for the reform of the Security Council. Generally, the position of the African group on the reform of the Security Council, as espoused in the Zerwini Consensus and the Self-Declaration, is anchored on demands for a reform that will ensure the legitimate right of the African region, a huge constituency of the UN membership and global community, to a fair and equitable geographical representation in the Security Council, taking into account the principles, objectives, and ideals of the UN Charter for a fairer world based on universalism, equity, and regional balance within the United Nations system. Our topic bears much relevance on the use of accountability, as accountability of the Security Council is closely linked to the need for equitable representation. Accountability, moored on the principle of equitable representation, will give an effective voice to the entire constituency of the UN membership. It is our view that an institution that is equitably represented will be more accountable and transparent. There's also an equitable representation accountability nexus to the retention of the veto in the reform negotiations. In principle, Africa is opposed to the veto. However, it is of the view that so long as it exists and as a matter of common justice, it should be made available to all members, permanent members in the Reformed Security Council. This democratization of the veto, if you may, will lead to its conscientious use, as it will engender more good faith negotiations, accountability, and transparency. On this note, I am pleased to state that we see discussions, including this one, as part of effort to galvanize the necessary will to support the reform of the UN Security Council, inclusive of reforms on the retention, use, or threat of use of the veto. We therefore look forward to fruitful deliberation as I extend our very best wishes to all of you. Thank you so much.
Thank you very much, Your Excellency. I now have the honor and pleasure to introduce the 4 panelists who will share their views and reflections on the topic, starting, of course, with Professor Jennifer TRAHAN, a professor of NYU Center for Global Affairs and director of their concentration in international law and human rights. She's also the author of the book, Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, that was published this year by the Cambridge University Press. That book already won the 2020 ALIE Book of the Year Award from the American branch of the International Law Association. And let me just add, Jennifer, a great pleasure always to be with you in these events. We also have with us Ambassador Hans Corell from Sweden, who served actually in the Swedish judiciary at the beginning of his career prior to joining the Ministry of Justice, where he became the chief legal officer and later the ambassador and under secretary for legal and consular affairs in the Ministry of Foreign Affairs. Many of us had the pleasure to work with him in his capacities under Secretary General for Legal Affairs and the Legal Council of the United Nations, when he was involved in the establishment of the International Criminal Tribunals for the former Yugoslavia and Rwanda, the Special Court for Sierra Leone, and the Extraordinary Chambers in the Courts of Cambodia. He was also the Secretary General's personal representative at the Rome conference that adopted the Statute of the International Criminal Court. Welcome also to Justice Richard Goldstone, former prosecutor of the International Criminal Tribunal for the former Yugoslavia and Rwanda, and more recently, as we all know, the chair of the Independent Expert Review of the International Criminal Court in the Rome Statute System. And finally, Professor Allan Rock, President Emeritus and Professor of Law at the University of Ottawa, former Attorney General of Canada and Canadian Ambassador to the United Nations. So Jennifer, I will start with you, if you allow me, with the core question of this topic. This panel is about the veto power being used while there are ongoing atrocity crimes being committed. Can you tell us, based on your extended research and the conclusions that you draw in your book, what the problem is and your proposal specifically for addressing it? And I understand obviously that you will use your remarks and your study that is now available in the book and addresses the topics in more depth.
Great. Thank you so much for that question and that lovely introduction, Anna Miriam. And I also want to thank the missions of Sierra Leone and Costa Rica and the Kingdom of the Netherlands for their important sponsorship of our panel, as well as International Center for Transitional Justice. And thank you to Ambassador for those strong opening remarks. And I'm delighted to be joined by my panelists. It's an honor to appear with you. So yes, I will first discuss the problem that I see the veto being cast while there's ongoing atrocity crimes. And here I am using atrocity crimes as shorthand for genocide, war crimes, and crimes against humanity. I will then situate this practice within our system of international law and the obligations of that system. And then I will suggest concrete proposals for solutions. At the end, in a quick second round of remarks, I will highlight the problem of the veto of a referral to the International Criminal Court and how blocking such a referral squanders any deterrence potential, potentially fueling more crimes and blocks accountability. So the veto being used in the face of atrocity crime is problematic It is at odds with various aspects of our system of international law, and the way it is used exacerbates deadlock within the Security Council and fuels recurring cycles of crimes and violence. Let me start with some examples. Historically, the veto likely delayed the dismantlement of apartheid in South Africa. During the Rwanda genocide, it was more that the threat was there. The word genocide must not be used, and this contributed to the UN not sending in added forces. As to Darfur, Sri Lanka, and Myanmar, we again see relative passivity out of the Security Council while there are horrifyingly large atrocity crimes. Again, here it is the veto threat. And note that the veto threat can block the council as effectively as an actual veto. So for example, as to Darfur, we see veto threats, and what these do is they water down sanctions, they weaken them, they weaken the peacekeeping mandate, and they delay the peacekeeping deployment. All the while we have accelerating war crimes, crimes against humanity, and charges of genocide. The death toll is around 450,000. As to inaction regarding Myanmar, we have a slightly different scenario because we have mainly, early on in 2007, one actual veto. And just imagine if in 2007, there had been the courage to condemn the crimes in Myanmar and maybe ratchet up to other measures, but there wasn't. So it is not only the resolution that did not pass that causes the harm, but this provides a green light to perpetrators on the ground that there is a protector on the Security Council who will shield them. And it certainly indicates to those on the ground, the council is unlikely to be able to ratchet up to measures. Regarding the conflict in Syria, we now have a dispiriting 16 vetoes, many double vetoes. These can be grouped into vetoes that prevented recognition of crimes, blocked the ICC referral, blocked various measures related to chemical weapons, including an inspections regime known as the JIM, Joint Investigative Mechanism, that was attributing responsibility to the side using the weapons, and even blocked humanitarian relief. And note, as to the Joint Investigative Mechanism, when these investigations start, we do see a decrease in chemical weapons attacks, and with veto of the mechanism, we see accelerating chemical weapons attacks. So on this instance, I think we can see a direct linkage between the veto on the East River to fatalities in the country. Put together, these examples show the way the veto is used when there are otherwise 9 votes by other members on the council that they are prepared to take some kinds of measures. These vetoes are actually costing lives and contributing to the prolongation of atrocity crimes. My book suggests we need to look at this practice in light of the obligations of the international legal system. It looks at it from 3 levels, and these are independent arguments. It looks at the level of jus cogens, the obligations of the UN Charter, and foundational treaties. And of course, the veto is found in Article 27.3 of the UN Charter. It doesn't say the word veto, but it's in the voting provisions. This is, of course, a lower source of authority than, for instance, jus cogens. And I should say, I'm here making a very, the 2-minute presentation of my legal arguments. They're over 120 pages in my book, so the full articulation can be found there. So the veto is below what we call jus cogens. So jus cogens is our highest level of protection in the international legal system. And we say the prohibition of genocide, war crimes, and crimes against humanity are all at this very highest level of the law. The Charter is in a subsidiary level. And all bodies under international law are subject to jus cogens. So at minimum, we could say that to have these kinds of vetoes seems inconsistent with this jus cogens protection. A more aggressive formulation is that sometimes our vetoes seem to be facilitating jus cogens crimes. And additionally, the states casting the vetoes or negative votes are breaching duties of state responsibility. And here the ILC, International Law Commission, in its articles on the responsibility of states for internationally wrongful acts, Article 41.1, recognizes a duty of states to cooperate to bring to an end through lawful means any serious breach of an obligation arising under a peremptory norm of general international law. So there are three ways that we see this tension with jus cogens. A second argument is simply the veto needs to be seen in the context of the totality of the UN Charter. The UN Charter, of course, is framed by its purposes and principles in Articles 1 and 2, including respecting international law, respecting human rights, the obligation of good faith, and the obligation to cooperate in solving problems of a humanitarian character. I think it is clear the current veto use is far out of line with these obligations of the Charter. Under Article 24.2 of the Charter, the Council as a whole is bound by the purposes and principles of the UN. Note then, if the Council as a whole is bound, individual permanent member states necessarily cannot have power that is greater than that of the Council as a whole, but also individual states are bound by the terms of the UN Charter, and the permanent members are also individual states. A third level of obligation is that found in treaties such as the Genocide Convention and Article 1, its obligation to prevent genocide, and in the 1949 Geneva Conventions, Common Article 1, and the obligation to ensure respect for the Geneva Conventions, an obligation also found in certain of the additional protocols. All permanent members are parties to the Genocide Convention and at least the 1949 Geneva Protocols. The ICJ in the Bosnia-Serbia case shows there is serious content to this obligation to prevent genocide. It is a due diligence obligation based on a state's capacity to influence, but it is not triggered only when the genocide is occurring, because it is an obligation to prevent. It is triggered when there is a serious risk of the crime. And at that point, states parties have this due diligence obligation to do all that is legally at their disposal based on their position of influence. And the permanent members, by virtue of being permanent members and their bilateral relationships, they also hold the key to collective international action because of their role in the Security Council. These create weighty responsibilities. Also, the ICJ holds this is not solely an internal obligation. It is not just to prevent genocide in one's territory, but an external obligation to prevent genocide elsewhere. The same is true of Common Article 1. The International Court of Justice holds this in the Wall and Nicaragua cases, that this creates such similar internal, external obligations. And the International Committee for the Red Cross makes clear this is also a due diligence obligation. It might be difficult to say what exactly is required by due diligence, but I think we can say that some of the vetoes we are seeing appear to be the antithesis of due diligence. When other members of the Council, particularly at least 9 of them, are prepared to take some measures to try to stop the crimes, to block this seems the antithesis of due diligence to try to prevent crimes and ensure respect for the Geneva Conventions. For crimes against humanity, we don't have a comparable treaty source as of yet. One can make the same arguments, but it's based on general obligations of international law. To conclude, I will suggest 3 measures that states can take. They can use these legal arguments at every appropriate opportunity, particularly at the United Nations, and continue to make clear these problematic legal practices, something that states have already started to do in interventions at the UN, and I've compiled some of these in my book. That states could also consider working to have the General Assembly issue a resolution reflecting these requirements of existing international law, and the General Assembly could request of the ICJ, International Court of Justice, an advisory opinion on a question such as, is all veto use while there is ongoing or the serious risk of genocide, crimes against humanity or war crimes consistent with international law. Thank you. I'll end here.
Thank you very much, Jennifer. I will now turn to our panelists to actually seek their views on this very interesting formulation and the framing of the problem that you proposed, starting with Ambassador Correll. Ambassador, do you agree with Professor TRAHAN that the way the veto is used in the face of atrocities crimes is problematic? And what do you think about her proposed way to move forward?
Yes, I do indeed agree. And I think it is very important that states now carefully study the reasoning of Professor TRAHAN and see whether this is not the basis for taking a new start, as it were, on the manner in which the Security Council behaves. I experienced the Security Council very closely during my 10 years as a UN Legal Counsel before the from 1994 to 2004, 3 years at Boutros Ghali and 7 years at Kofi Annan. And of course, I was very sad sometimes when I saw how the veto was used. So when I saw Professor TRAHAN's book, I said to myself, I do hope that member states of the UN now study carefully this reasoning and see whether it could not be the basis for further action here. And also, I would like to mention that I continued working with Kofi Annan after he left the UN. And in 2008, he was appointed chairman of the panel of eminent African personalities that worked for the, shall we say, Kenya issue after the presidential election in 2004. And he chaired this panel, and during this time, he managed to have the parties sit down, negotiate an agreement, and we also elaborated legislation that was to govern a big grand coalition government in the country for 5 years. And then he got his mission in Syria. And I remember sitting with him discussing in April 2012, can we work in Syria as we worked in Kenya? And he felt silent for a while, and then he shook his head and said, no, Hans, we can't. I do not have the support of the Security Council in Syria that is absolutely necessary for achieving a result in Syria. I'm going to leave this mission, which he did in August the same year. So when I saw Professor TRAHAN's analysis of the vetoes cast, of course, that made me remember what we experienced then, Kofi Annan and I, at that instance. So I think it's very, very important indeed that we now look carefully at this and see whether one could not take steps forward. And of course, now, since this is a side event of the Assembly of States Parties, the question is, what can the states parties do here? And in this situation, I would like to suggest the following. First of all, and I direct myself to those who listen, since you represent your governments, you should pay particular attention to the proposals in Professor TRAHAN's book. You should convince your governments that they should join hands with other governments in the General Assembly of the United Nations and adopt a resolution requesting the International Court of Justice for an advisory opinion addressing the question whether international law, as it has developed after the adoption of the UN Charter, contains limitations on the use of the veto power by permanent members of the Security Council in situations where the Council considers adopting a resolution under Chapter 7 of the Charter of the United Nations and to stop and to punish genocide, crimes against humanity, and war crimes. And also, of course, the General Assembly could, by resolution, also recognize these legal elements or limits and call on the permanent members to exercise a consequential restraint in the use of the veto or its threatened use relating to genocide, crimes against humanity, and war crimes. And the veto, even if it is granted by the UN Charter, is not paramount to the norms of the Charter or other norms of international law, as Professor TRAHAN reasons. It's one provision in the Charter, but it is subject to the rules and norms of international law. And I feel very strongly about this because I think the UN is a fantastic organization. But the weakest link sometimes is this most powerful organ, the Security Council. And the purpose of the Security Council is to, shall we say, stay succeeding generations from the scourge of war. And that is why the Council has the supreme responsibility for the maintenance of international peace and security. And here, I think a very important element is crime prevention. And if the Council doesn't behave in a manner that it prevents crime, then it simply doesn't do its job. And if the Council actually asks the International Criminal Court to address a situation somewhere, like they have done in Sudan and in Libya, then the Council should follow suit and see to it that the court is supported, and in particular that the prosecutor is supported. And I haven't seen that. And until the Council does this work properly, they actually trigger new conflicts in the world. And warlords and dictators will not see that they will come after them if they violate the law. So therefore, I think it's so important that we have a system that clearly establishes the duty of the Security Council. And this could be done through an advisory opinion by the International Court of Justice. And furthermore, if you look to the horizon, we have to realize that there are enormous threats to humanity today. The climate change and the rising world population. We were 2 billion when the UN was founded in 1945. We are getting close to 8 billion people on the globe now. And the climate change is just terrific. And I'm following it very closely since I do a lot of work on the polar regions, in particular the North Pole here. These will be tremendous threats to security in the future. And African colleagues have told me that an area south of Sahara or the Sahel region, which is almost as big as Antarctica and the North Pole, the Antarctic Sea, might be so arid that people cannot live on what is grown on the ground there today. We will have then refugees, climate refugees. And where are they welcome? We see already in Europe how this has really made a tremendous sort of tensions among the countries in the European Union on how to receive these refugees. So I think that what I would like to see in the Security Council is statesmanship. Statesmen and women who can look to the horizon and see to it that their responsibility is not their own state only, but it's the humanity, and not the present generation, but also coming generations. And if I may close on a note, maybe it was not please African ambassadors so much, but I have written an article about Security Council reform, and you can find it on my website, just Google my name, and the title is Security Council Reform. The Council must lead by example. And here I'm very concerned about that the reform is only discussing extensions on the Council. What I think they should discuss is the behavior of the 5 permanent members and look at their responsibility and see whether it should not be respected in a better manner. Thank you so much.
Thank you very much, Ambassador. Judge Goldstone, can I please ask you to weigh in on the same question?
Right, well, thank you very much indeed for inviting me to join this excellent panel. I want to address my remarks specifically to the effect of Professor TRAHAN's book, and if I may call it her project, on the International Criminal Court. For some years, and even more so today, there are criticisms of the International Criminal Court to the effect that the crimes being investigated and prosecuted by it relate to war crimes that in their magnitude, horror and gravity are really eclipsed by those committed in countries that are not before the International Criminal Court. One hears so frequently that it is unfair that the crimes committed in wars in Africa in particular are being investigated and prosecuted by the ICC, but not those in horrendous, but not those horrendous violations of international law being committed in Syria. Too many people, including some politicians and journalists, appear to be unaware that the ICC's jurisdiction is limited not only by complementarity, but that it is also limited to investigating crimes committed in or by nationals of states that have ratified the Rome Statute. The problem, of course, that Syria is not a state party to the Rome Statute, and neither are the nations that are waging a surrogate war in Syria, such as Russia. The ICC, unfortunately, has no jurisdiction in respect of war crimes committed in Syria. It is through no fault of the prosecutor that those responsible for the heinous crime are not before the International Criminal Court. Of course, this makes it an unfair system. We must admit that. And at the same time, some justice is preferable to no justice, but the system needs improvement. If the ICC is truly to succeed, it needs to have jurisdiction over atrocity crimes, no matter where or by whom they are committed. The only way the ICC might achieve jurisdiction over atrocity crimes being committed in Syria would be a referral of the situation by the Security Council. It would have to act under the provisions of Chapter 7 of the United Nations Charter and Article 13b of the Rome Statute. There can be no doubt that the situation in Syria constitutes a threat to international peace and security. The Security Council clearly has competence to refer it to the International Criminal Court. And there has been, as it emerges from Professor TRAHAN's book, there has been no shortage of attempts to have the Security Council make such a referral. Efforts to that end by members of the Council have failed, only because of the exercise or threatened exercise of the veto by Russia and or China. We have recently seen a series of 16 dispiriting vetoes by Russia, some joined by China, blocking various resolutions relating to Syria, including a referral to the ICC. Many states are frustrated at the will of the majority of states being thwarted by the use of the veto power. In Chapter 3 of her book, Professor TRAHAN considers the attempts that have been made over almost 2 decades to rein in the use of the veto, all to no avail. In particular, a voluntary limit on the veto imposed on themselves by the Permanent Five is doomed to fail. Realpolitik will always prevail. Similarly, there is no prospect at all, in my view, of the abolition of the veto power. After all, the permanent members have a veto over that removal. Thus, frustration of an overwhelming majority of states in the General Assembly led to the adoption on the 21st of December 2016 of Resolution 71/248, establishing the international, impartial and independent mechanism to assist in the investigation and prosecution of persons responsible for the most serious crimes under international law committed in Syria since March 2011. It is more commonly referred to as the mechanism, or the IIIM. The mandate of the mechanism is to assist in the investigation and prosecution of persons responsible for the most serious crimes under international law which are being committed in Syria. Its purpose is to facilitate and expedite fair and independent criminal proceedings in accordance with international law standards, in national, regional, or international courts or tribunals that have or may in the future have jurisdiction over these crimes in accordance with international law. The problem, of course, is that the evidence collected by the mechanism is not presently of any practical significance at all. There is no court having jurisdiction to consider that evidence or to call any of the perpetrators to account. If Professor TRAHAN's project were to succeed, there would be a greater likelihood of the Security Council referring situations of atrocity crimes to the ICC. If states become aware that they will likely not be protected by the use of the veto power, and particularly heads of state, in at least some situations that might act as a powerful deterrent. At the very least, it would enable the ICC to become seized of all atrocity crimes that are not appropriately investigated and or prosecuted by states that have domestic jurisdiction over those crimes. The proposed request from the General Assembly for an advisory opinion from the International Court of Justice, as Ambassador Corral has indicated, is a constructive approach. I would suggest that it deserves support from the members of the United Nations. In conclusion, I would say that little reliance can be placed on universal jurisdiction. It is both comparatively rare that domestic courts have that jurisdiction, and it relates idiosyncratically in any event to situations peculiar to the persons accused. Thank you very much.
Many thanks, Justice Goldstone. Ambassador Professor Rock, your turn, if you can enlighten us on your views on the issue.
Thank you, Anna Miriam. Excellencies, distinguished representatives of states, parties, friends, and colleagues, I'm grateful to be part of this discussion today. The Security Council, of course, is the most powerful of all UN organs. The Charter invests it with immense authority, as well as with grave responsibilities. Among other things, the Council is empowered to determine the existence of a threat to peace, and then to decide what measures are to be taken to maintain or restore peace, including, if necessary, action by air, sea, or land forces. There are few threats to the peace more urgent and compelling than the possibility of mass atrocity. When the Council becomes aware that genocide, war crimes, or crimes against humanity are in progress or in prospect, it has both the duty and the means to stop it. Indeed, just 15 years ago, in the shadow of the Rwandan genocide, still feeling the shame engendered by our failure to stop it, UN member states unanimously acknowledged and accepted our collective responsibility to prevent, and if necessary, to stop mass atrocity, and unanimously agreed that they would do so, quote, in a timely and decisive manner through the Security Council. Our experience since, of course, tells a vastly different story. When the government of Myanmar in 2017 turned its military forces against its own population, committing against the Rohingya of Rakhine State what a UN fact-finding mission has called a genocide, there was no collective response by UN member states through the Security Council. As the Syrian government of Bashar al-Assad, in the years since 2011, murdered and gassed countless numbers of its own population and forcibly displaced millions more, there was no collective response through the Security Council. Nor has the Council exercised its authority, referred to by Justice Goldstone, to refer to the International Criminal Court allegations of mass atrocity crimes in these and other cases. The reason in each instance for the Council's inaction? The veto. Giving the right of veto to the 5 permanent members in 1945 was the political price paid to persuade the big powers of the time to join and allow the creation of the United Nations. Even at that, the historian Stephen Schlesinger points out in his definitive history of the 1945 negotiations in Act of Creation, the purpose and use of the P5 veto was understood then to be conditioned and nuanced. It was to apply only to substantive decisions, not procedural matters, which were defined broadly. And where a dispute arose to which a P5 state was a party, that permanent member was to abstain. In practice, the veto has become, in the years since, something much more sinister. In the manner of its exercise, the veto is an arbitrary power too often employed in a cynical and unprincipled way, not to safeguard a legitimate national interest of a P5 member, but rather to shield from scrutiny or investigation or intervention a client or proxy state of the permanent member. And in the manner of its exercise, the veto has been used repeatedly to block a collective response to mass atrocity, flying in the face of the 2005 unanimous resolution committing UN member states to prevent or stop the commission of such crimes. As Jennifer TRAHAN documents in her book, repeated efforts have failed over the decades to persuade the P5 to accept even a measure of restraint in the use of the veto when mass atrocity crimes are in issue. Their refusal to do so, with the shameful result that genocide and crimes against humanity have been allowed to continue, has done deep and lasting damage to the credibility of the United Nations. UN member states frustrated by the veto in such cases felt until recently that they had three less than satisfactory options. First, to establish measures independently to preserve evidence should a prosecution eventually become possible, such as the mechanism in Syria to which Justice Goldstone referred. Second, to pursue a declaration of state responsibility in the International Court of Justice, as the Gambia has done in relation to Myanmar. And third, to consider or perhaps seek authority from a body other than the Security Council, which, while it might not convey a legal authorization, will add legitimacy to an intervention which might prevent the imposition of the consequences of illegality. Professor TRAHAN has now provided a fourth option. She has laid out with clarity and coherence the basis in law for asserting that the veto is not an unlimited right in cases of mass atrocity. On her analysis, there are sound legal arguments to support the position that the P5 veto is not beyond challenge, and she provides a path forward as well. By urging the General Assembly to refer these issues to the ICJ for an advisory opinion, Jennifer TRAHAN suggests a means for obtaining an influential and persuasive pronouncement that might inhibit future abuses by P5 states of their veto in cases of mass atrocity. Colleagues and friends, I conclude by saying that we cannot allow one or two UN member states to betray the promise of the Charter, to frustrate the expressed will of all UN member states favoring a collective response to mass atrocity, to abandon the victims of genocide and other atrocity crimes. And that is why we, along with many others, urge member states in the General Assembly to support a referral of these issues to the International Court of Justice. Thank you.
Thank you very much, Ambassador Rock. Jennifer, inevitably in the discussion, the issue of the veto used to block also the ICC referral came up. Can you just elaborate a little bit more and discuss this specific issue?
Yeah, thank you so much. And yeah, we are at a side event of the Assembly of State Parties, so I wanted to particularly focus on this question. And the most recent veto of a referral, or the one we've had, is been related to Syria. It was a resolution co-sponsored by 65 UN member states. And this, of course, indicates a wide measure of support for this referral. And that veto, of course, blocked the ICC's ability to prosecute the crimes in Syria as a whole. I want to go back to examine some of the crimes acknowledged to have been occurring on the date of the veto. And I do this for two purposes. One is to tell you about the crimes that the ICC won't be prosecuting. And secondly, it is to look at the legality of the veto cast. And is it permissible to block prosecution, investigation, and prosecution of all these crimes? Is that acceptable under the obligations of our international legal system? So by the date of the veto, May 22, 2014, we had already had the largest single chemical weapons attack. This was the sarin gas attack on the Al Ghouta region, thought to have killed more than 1,000, with an estimated 3,000 suffering from neurotoxic symptoms. By the date of the veto, the International Independent Commission of Inquiry on the Syrian Arab Republic had already found government forces and affiliated militias committing large numbers of crimes against humanity and war crimes. The crimes against humanity thought to be occurring as of that time include murder, torture, rape, enforced disappearance, other inhumane acts, and forcible displacement. The war crimes thought to be occurring committed by government forces and affiliated militias include arbitrary arrest and detention, unlawful attack, attacking protective objects, pillage, destruction of property, summary execution, torture, hostage taking, murder, execution without due process, and rape. The Commission's findings particularly include documentation of deliberate targeting of medical personnel in hospitals, denial of medical access, destruction of cultural heritage, as well as laying siege to towns in order to make conditions of life unbearable by preventing incoming supplies of food, water, fuel, medicine, and shelling water towers and electric generators. The commission, as of the date of the veto, had also documented extensive anti-government crimes groups by opposition forces, such as war crimes, including murder, torture, hostage taking, attacking protected objects, sentencing and execution without due process, pillaging and besieging, and indiscriminately shelling civilian towns and neighborhoods. So what the blocking of the ICC referral meant, that any deterrence regarding any future crimes in Syria after the date of the veto, any deterrence potential was squandered, because the veto sent a very clear signal that there was no jurisdiction over the situation at large in Syria. This meant, as referred to previously, that prosecutions can only be brought against those who find themselves in jurisdictions where they are able to exercise universal jurisdiction or other theories of jurisdiction. What this means is that you will not necessarily have any prosecution of the worst crimes and the perpetrators most responsible, because no court can holistically conduct this kind of investigation and prosecution and bring these cases. Blocking the referral also meant the ICC has no jurisdiction over the suspected genocide by Daesh of crimes against the Yazidis. And had there been any ability to deter the crimes against the Yazidis, this also went out the window with that referral being blocked. Again, we need to examine that kind of vote against the requirements of international law. I've outlined the three major levels of analysis, but when we're talking about blocking investigations and prosecutions, there are additional arguments one can make, because there are obligations to investigate and prosecute certain of these crimes. These are also detailed in my book. So thank you. And I will just add a two-finger to Professor Rock's wonderful remarks that I would not put all permanent members in the same grouping, in that 2 permanent members actually endorse veto restraint. And I think this is an important difference. And but it unfortunately shows where we are blocked, because 3 permanent members do not join. And France and the UK have endorsed voluntary veto restraint. They are joined by the 123 parties to the Act Accountability, Coherence, and Transparency Group's Code of Conduct, and the 105 states that have joined the French-Mexican Initiative. So there are states working against this, but these are measures to voluntarily veto, restrain the veto. And my arguments are different. My arguments are there are legality problems. So
thanks, Jennifer. Thank you.
Thank you very much, Jennifer. Actually, I'm turning now to the other panelists if they wish actually to add or complement or comment on Professor TRAHAN's analysis of the blocking of the ICC referral. Maybe I can start with you, Professor Rock, since Jennifer was pointing at one of your remarks. If you have anything you would like to add.
Well, of course, Jennifer's refinement is quite right. Some members of the P5 have indeed, France and the UK, have indeed accepted the concept of restraint as proposed in that initiative. But the fact of the matter is that they can do that with no political cost, because they know that there's no chance, no foreseeable possibility that the other members of the P5 will also endorse restraint. And I can recount from my own experience in the negotiation process for the responsibility to protect in 2004 and 2005, the International Commission on Intervention and State Sovereignty, in proposing responsibility to protect as a set of principles to govern collective response to mass atrocity, had very much recommended restraint on the veto in such cases. And I sat with each ambassador from the P5 during those negotiations to talk about the prospect of self-imposed restraint. And I can tell you that they may have expressed their refusal in various ways, some more polite than others, but the message was loud and clear. Fundamentally, there was no preparedness to attach any condition, any restraint, any limitation to what they saw as their unbridled and unqualified right to exercise that veto. So it's a very, very tough political challenge. And while we may speak of UN Security Council reform, let's bear in mind that for decades now, in terms of the working methods, have been efforts to persuade members of the council to adopt practices and approaches which would be more democratic and more sensitive to the urgent humanitarian needs in the cases before it, and largely without significant success.
Thank you. Ambassador Corral.
Thank you. First, I'd like to say that I agree with what Justice Goldstone and Ambassador Rock said, and in supporting also Professor TRAHAN's reasoning. I think it's extremely important that we make a distinction here between 1945 and today, because the development of international law has been tremendous since then. And the UN Charter is like a national constitution in a sense, that it is a living document and it has to be construed in light of development. And when we see the development of jus cogens and new conventions being adopted, the Geneva Conventions 49, the Genocide Convention, so forth, these are all elements that build up a legal system now. And it is against this system that one has to examine the provision on the so-called veto in the UN Charter. And this is why I think it's so important that if we could have a clear legal opinion about the use of the veto, then it would be a tremendous advantage. This is not to say that, shall we say, promises from states not to use the vetoes could also be a useful element among others. And I know that in the Act, which was referred to by Professor TRAHAN, I think there are now 123 states that have endorsed the Act, and 2 of them permanent members of the Security Council, United Kingdom and France. But we have to have China, Russia, and the United States on board here too. But this does not mean that one should not try to get this solved in a legal manner, because if we would have an opinion that it would be a violation of international law to put in a veto against the resolution where the Security Council attempts to stop a genocide, for example, or refer to a case to the International Criminal Court, then it would have a great importance. And also we must see whether the permanent 5 members could not for once sit down and have a serious discussion about their behavior, because the manner in which they behave actually feeds new conflicts on the globe. If they demonstrated just once that they would go after a dictator or a warlord, that would send a very powerful signal to these kind of people around the world that maybe we have to be careful, they will say, they will come after us otherwise. This is what I think is so important here. Thank you.
Thank you, Ambassador. Judge Goldstone.
Thank you, Anna Miriam. I would like to make a few remarks about the threat of the use of the veto, because it seems to me, and I think it's commonly accepted, that there's a pernicious practice amongst the P5 that in many cases, in fact, the overwhelming majority of cases, the very threat of the veto stops a resolution being put to the Security Council. I had one personal example in one matter in 2004, when the then Secretary General Kofi Annan requested me to join Paul Volcker in setting up an inquiry into the United Nations Oil for Food Program. And Mr. Volcker sensibly had refused to accept this appointment if there wasn't at least a presidential statement or a resolution of the Security Council welcoming the establishment of the committee and requesting member states to cooperate with the committee. He realized that this wouldn't be a resolution that that would compel compliance by states parties, but he wanted that resolution to waive in the faces of bankers and other people from whom information was needed. And I remember sitting in Mr. Volker's office when he spoke to Kofi Annan, who said, there's no hope of a resolution because Russia has threatened a veto. And that was the position, and Volker said to the Secretary General, well, you know my position, without the resolution, I'm not prepared to accept this position. And the Secretary General said, please call John Negroponte, who was then the permanent representative of the United States at the United Nations. He would like to discuss it with you. Paul Volcker got through to Ambassador Negroponte, who told him that the position's hopeless because not only is Russia threatening to veto, but so is France. And he said, there's no point in putting a resolution in the face of two threats. Volker said, Ambassador Negroponte, if you want me to be involved, I insist that the resolution is put. If it's vetoed, I'll reconsider my position. I don't think many people could have dictated as Paul Volcker did to the ambassador, but the next day, the resolution was put on the table of the Security Council and it was unanimously passed. And I remember Paul Volcker saying to me, of course it was passed. Russia or France would not have gone public in opposing an inquiry into well over $1 billion of alleged bribes and corruption involving Saddam Hussein. And I had a peep at the first question on the Q&A. If threats of the veto were not accorded the importance they are, if states threatening the veto were forced to justify why they were vetoing, I think that very practice would have a salutary effect on some of the use of the veto.
Thank you very much to all our panelists. I am already receiving some very interesting questions, and therefore I would start putting it to you. The first one is actually starts with a reality check, considering obviously where we stand now. How could we think about a reconfiguration of the veto power to start with, maybe as a power to be used only in exceptional circumstances, strictly pertaining to maintaining peace and security, and also bound to a duty to properly motivate the decision when the veto is cast. So at least the duty to provide a motivation could impose an element to make the permanent members accountable for its use. Jennifer, would you like to start?
Yes, thank you. Thank you for that question. So the question is posing, should we use maybe 3 other criteria? Right motive, peace and security, and the first one as well, which you just read out. And just technically, how would you accomplish this? Well, the one thing we haven't discussed in the bulk of our panel is charter amendments. So I think, and this audience probably all knows that charter amendments are veto proof. They require all permanent members to agree. So, it's very hard to get an actual charter amendment related to the veto. And that's why we're talking about other proposals. So if you had these other criteria, and if you got all permanent members to agree, I think this could be helpful, but that's really the catch. And then if you have an agreement, is that just a voluntary agreement? Well, if it's voluntary, it's not legally enforceable. I'm not saying it's without validity, these voluntary measures. I think they're all going in the right direction. And there are many ideas trying to work on this. I know Liechtenstein's separate proposal that every time the veto is cast, there should be discussion in the General Assembly. And this also sheds light on the practice and I think is helpful. So it's how would you get this achieved? So my proposal is to look at actual legal obligations. And this takes us out of the realm of who agrees to what politically, and we look at actual legal obligations. So I have a separate way of doing this. There are different ways you could propose this, but do you have a proposal that the 5 permanent members will accept? And even then, if it's voluntary, there are limitations. So thank you.
If I may?
Yes, of course, of course.
Thank you. Very briefly, I have thought a lot about the threat of the veto. And I think a very important element here is that even if there is a threat, a member could ask for a vote, because that would force the state that's threatening the veto to cast the veto and go down in history having made this kind of decision. And that would not be a nice record. And also, I've given thought to further elements here in the development. And I think that members of the council could discuss also the permanent 5, an agreement not to use the veto under certain circumstances. And that agreement could be made legally binding. It was a proposal that I made only 3 years after I had left the UN in a letter to members, 2008. So you could have actually a legally binding agreement among the permanent 5 members not to use the veto. But this doesn't mean that I think this would be a better solution than the one suggested by Professor TRAHAN. Thank you.
If I may,
Of course.
two quick points. First of all, I think the enduring value of the contribution that Jennifer TRAHAN has made here is that she has proposed a route based in law, not politics, not diplomacy, not persuasion behind closed doors, not enticing or encouraging, but having a court make, at least in an advisory way, an adjudication on the substance of the legal analysis that she's put on the table. And that way, if we were to get an advisory opinion, perhaps not binding, but influential, we might get results that are not available by political means that to date have failed. My second quick point is that if, the record shows that states exercising the veto at the Security Council table almost always do provide a reason. You'll see that it's mostly insubstantial, self-serving. It's can't. It's Russia saying, well, the resolution fails to reflect the complexity of the situation, doesn't take a balanced approach, doesn't take into account all the competing interests, the sort of stuff you'd expect in the world of diplomacy. So asking for an explanation of veto or to disclose the motivation may not get us where we want to go. On the other hand, the S5 proposal that there be a discussion in the General Assembly after each veto has the capacity to embarrass, to call for greater explanation, and to provide a forum of high profile where member states can express frustration and dissatisfaction with the abusive use of the veto power. Thank you.
Justice Goldstone, do you have any thought?
Well, nothing really to add. I think it's important. I think an advisory opinion, even though not binding, would embarrass and would shame some governments exercising the veto, especially in relation to protecting genocideers and other people responsible for the perpetration of atrocity crimes. So it's not without political power. It might not be legally binding, but I think certainly it would call on members of the P5 exercising the veto to explain why this is not contrary to international law as set out in such an advisory opinion.
Thank you. Actually, this allows me to follow with a very important question from Mr. Carswell. the international law, from the International Rule of Law Initiative in Canada, who is asking a very pertinent question, but which what would be the consequences then in a situation where the veto is recognized as illegal or unlawful? What would be the consequences for the permanent members that have casted it? Jennifer.
Thank you, Andrew. So yeah, where there is a violation of a duty should be responsibility. That's a basic corollary there, yeah. So my proposal is initially to seek an advisory opinion. So this would be very much in the abstract. So simply looking at the legal obligations and how the veto power aligns with them. I think, you know, if that were achieved, and that might be many years off, one could also potentially envision, could there be a contentious case? And I think that would be maybe the best way to trigger direct responsibilities if that route could be pursued. I haven't yet envisioned, you know, how that would be, but that maybe would be the follow-up step to looking at one actually under, for instance, you know, the Genocide Convention, and pursuing that. So.
Yes, actually, another very interesting question here. There are many. I'm very pleased with how active and interested the audience appears to be. But a very interesting question, Jennifer, is if you could discuss a little bit more how you envisage the steps that will be required for an ICJ's advisory opinion, and how, again, if and when we get to a positive opinion, how that could be enforced.
Yeah, thank you. Well, so I think, you know, the initial step is start talking about this, get this idea out there, get this idea socialized, have states understand what we're talking about. And so forums such as this, I'm delighted to be able to reach out to states parties. It does present that I'm merely an academic, so I cannot lead any kind of initiative within the General Assembly. It is for states to take up this issue. And it would have to be, as states have taken up the initiative of voluntary veto restraint, with the important first formulated, as Ambassador Rock pointed out, with the Canadian International Commission on Intervention and State Sovereignty. Then we have the S5 group of states. We have the Act Code of Conduct French-Mexican Initiative. There are states very much interested in this topic, and they would need to take this up within the General Assembly. So you would need to have the General Assembly request an advisory opinion. So states would need to push for that and then go to the ICJ for an advisory opinion. So I think those are the steps that we need to take. It would be terrific to have civil society backing this as well and urging their states. It would be terrific to have parliamentarians talking to their governments about the importance of backing this. It would be important, academics, we recently last week had a discussion on the website Opinio Juris, and academics to take up these issues and discuss it and push this idea, which is really different. We've spent 20 years pursuing voluntary veto restraint, and I'm suggesting it's time to turn a new chapter and look at legal questions. So we need to start in this trajectory, but it's ultimately the states that need to do this and to take this on.
Can I say, in addition to what Jennifer said, it seems to me that this is an issue which would really be wonderful for the African states to take up. And I say it as an African. The African Union some years ago, we all know, had turned its face against the ICC. That has changed for various reasons. The politics has changed, and African states, generally speaking, are coming more and more on board in an effort to improve the performance of the ICC rather than to pull out from the ICC. And this is an issue, it seems to me, that the African states and some of the Asian states should be concerned about. And that is the veto has been denied to all of Africa and all of Latin America. And it seems to me if these states, and really there is this upwelling of resentment in the General Assembly, it seems to me it's not beyond the realm of possibility in a fairly short time to get a substantial majority of the members of the General Assembly to agree to a resolution making this request from the International Court of Justice.
May I add here to what Justice Goldstone said, that this is very important indeed. And I know that Kofi Annan was extremely upset when African states threatened to leave the International Criminal Court. He gave a lecture in South Africa, by the way, and he was asked from the audience, what do you say about these states or these several states who want to leave the ICC? His answer was, and it's still on his website, they deserve a badge of shame. So I'm glad to hear that the attitude obviously is changing in Africa. And I hope that we can see a development. Something went wrong here. I lost contact. Can you hear me now?
Yes, we can hear you. We
Right.
lost you for a moment.
Yeah.
Back on.
Look, I think it's very important that we continue working here. And the suggestions I made for reform of the Security Council, they can actually be done without changing even a comma in the UN Charter, for the simple reason that it's very difficult to amend the Charter, as Ambassador Rock and others have said here. So we should be careful here and try to use statesmanship and look to the future and see the responsibility that the UN has, because I think the UN is indispensable, and not so much now, as more now perhaps than ever before, because of the common threats to mankind that I mentioned earlier in the discussion. Sorry about the technical problem here.
I'm very encouraged at Justice Goldstone's report of the current mood in Africa with respect to the ICC. Can I turn for a moment to the process by which we might get from here to there, Jennifer, in terms of the advisory opinion? It seems to me that you're right in saying the next step ought to be to socialize these ideas, get them out there, get people aware of them, test them in discussion groups with the objective of getting into place a group of supportive member states in the General Assembly who would form a core, call it the Friends of the Legality of the Veto issue. Like-minded states, 10, 12, 15, 20 of them who would meet, who would strategize, who would invite others to lunches and dinners, who would hold seminars in partnership with the IPI, who would get people across town in Turtle Bay talking about these ideas. And gradually over time, to build the list of supporters to the point where, who knows, a year or two from now, you might have a very significant body of support prepared to get behind such a resolution. And of course, there'd be threats and reactions from some members of the P5 and perhaps part of the Secretariat, I don't know. But I think that's the kind of movement we have to engender and encourage so that we end up, as we seek a legal result, with a political process to get there. That's what we need. And we need the support of states in the General Assembly. And I know that that effort is going on right now, and I encourage it. That's the way forward.
Yes, thank you very much to all of you. Actually, this leads me to another very pertinent question, which relates to the role of the General Assembly. So what could be the role of the GA beside the debates and the expressions by different member states during the debate? Should the GA put its own resolution specific request mandating the Security Council to take a particular action, for example, a referral of situations to the ICC. Jennifer.
Sure, and I think that was posed by Keith Best of the World Federalist Movement.
Right.
And thank you for that question. Yes, absolutely. It somewhat already was done in that, for instance, the Syria referral had 65 states signing on to it. So that already somewhat was a plea by General Assembly states for the council to pass this. This is, you know, another helpful way to build leverage, to have the General Assembly. But again, it's then requesting the Security Council. And if the Security Council is going to keep up with these vetoes, the way they've been used, it's again not going to get us where we need to be. So as Ambassador Rock has pointed out, I'm again attempting to take us out of the political framework and more into the legality framework and looking at the legal questions. There are many ways to tackle this, and I think we're going towards the same end. So I'm personally very much in favor of the French-Mexican initiative, the ACT Code of Conduct, Liechtenstein's new proposal. These are all good ideas. They're all working on the same difficulty. I think they're all complementary to each other, as well as this idea put forward by Keith Best.
Anyone has any thought on this specific issue?
Well, yes,
no?
can I add a thought?
Right.
I think also we shouldn't forget the important role to be played by the Secretary General. The Secretary General is the person to whom we look for leadership. And I think part of our attention should be focused on the Secretary General and the Secretariat to bring them around to this point of view, to develop support there as well. And I think that the Secretary General, who's now poised to announce whether he will seek a second term, you know, is in a very strong and influential position to lead on this issue. And I would hope we can look to the Office of the Secretary General for that kind of leadership. And I hope that member states approach the Office of the Secretary General to seek that leadership on this important question.
Could I add, in a different direction, I think it would be very important also to get a collection of as they were called with regard to the Rome Statute, a group of like-minded nations. Ambassador Rock will recall that Canada really was the leader of that group of like-minded nations, and I know the important role that Canada played in convincing President Mandela to actively join that group of like-minded nations, and the effect that South Africa had on getting ratifications from almost all of the members of the Southern African region. So it would be very important to find, and I'm sure a country like Canada should again take a lead in putting together a group of like-minded nations.
Yes, may I add that I remember when I was the legal counsel of the UN and we prepared for the Rome conference, how extremely important it was that states got together and formed groupings that made it possible to negotiate this very important treaty in such a short time, 5 weeks only in Rome. And of course, Kofi Annan was very engaged, and he had to disrupt travel in Argentina to be able to go back to Rome and be present when we started signing the Rome Statute on the 18th of July, 1998. And then he referred to the court as a gift of hope for coming generations. So I think we should give much thought to this. How can we encourage states to come together and to act together in the General Assembly to ask for a legal opinion? And as a lawyer, of course, I know that the legal opinion is not binding, but it has a very powerful signal, sends a very powerful signal, and it has been used in other contexts. For example, when they gave a legal opinion on the use of nuclear arms. And I've actually in my article suggested that maybe one should ask the International Court of Justice for a second opinion on nuclear arms, because I feel that it would not be possible today to use such arms within the realm of the Geneva Conventions. You cannot make a distinction between combatants and civilians. So I think it's a very serious situation. That's why one should use international court, and here the General Assembly can do so. Thank you.
Thank you very much. Jennifer, you have seen actually the question we have debated until now on the distinct difference between law and other measures or processes to advance on restraint and a more responsible use of the veto. But the question is now, if you envisage the role of soft law instruments from other states towards the P5 members that want to veto the resolution. So what could these instruments be, and how, if and how they could be effective?
Yeah, thank you for that. Interesting question. I just want to point out that, so when we're talking about the International Commission on Intervention and State Sovereignty and the French-Mexican initiative, the Act Code of Conduct, before the work of the S5, they were soft law, or this is how they were framed. So when you frame something as a political doctrine, it is not purporting to be binding law. A code of conduct is not purporting to be binding law. So this has been the approach to date. So I would like to shift it. But I think actually, I would like to just note that when we look at something like the R2P, and I think it is all too often thought on that one, I'm suggesting the responsibility not to veto within R2P was soft law. It never morphed into anything more solid. But some of the legal obligations underlying R2P are actually hard law legal obligations. And I think we take R2P far too loosely. And it's the same arguments that underline my vetoes argument that actually shows there's very serious content underlying R2P, and the R2P needs to be taken much more seriously. All of the legal obligations related to atrocity crimes, these are hard law obligations, and they underlie it. And the problem with the R2P agenda, in my mind, is right now it is blocked by the veto. And we've seen this so clearly with Syria. So my ideas also, I think, would revitalize potentially the R2P agenda and alleviate this kind of blockage. But I do think it is time to look at a hard law approach and do hard law legal obligations and take us out of the realm of soft law and political commitments, which are helpful. But if they don't result in all P5 joining them, we need to seek a different approach. Thank you.
Thank you very much. Ambassador Rock, you seem to have something to add.
Well, Jennifer's always thought-provoking, and her remarks are so important. There is a hard law, there are hard law considerations underlining this norm, as people refer to it, of R2P. You know, the obligation to prevent genocide is right in the convention, to which all member states are party, for example. But I also wanted to come back for a moment to this political process in the GA. Justice Goldstone's comments about President Mandela's role reminded me of the important role that South Africa played in the R2P negotiations and adoption. My friend Dumisani Khumalo was the ambassador for South Africa at the time. He chaired the small group that eventually negotiated the outcome document, and he made a lot of space for R2P, overcame a lot of objections with his skillful chairing of that process, and the fact that an African state was a champion of the principles was very important as well. But coming back to like-minded and the role of friends in the General Assembly, if you look at any contentious issue where progress has been made, think of the establishment of accountability mechanisms in children in armed conflict, Women, Peace and Security, Protection of Civilians, R2P itself. They all have friends groups in the General Assembly. They all have champions, ambassadors, permanent representatives who are prepared to convene, supporters, plot strategy with NGOs, develop common messaging, identify the best ways to persuade others to join them. And so I think that's what we really need at this stage. As we socialize the ideas and get people aware of them, also to start to gather together the level of diplomatic and political support, try to put this on an agenda and get a timetable to move it forward toward the concrete goals that we've identified here this morning. And I think that's a very exciting prospect. And I hope that Canada plays a leading role in that. I can think of a dozen other countries. It's important that it be an interregional group, not just from one region of the world, but across the regions. And I can think of a number of countries who be approached and be active members of such a group.
Ambassador Corral or Justice Goldstone, if you have, yes, please.
Thank you. Yeah, I had left the United Nations when the resolution on the responsibility to protect was adopted, but I was very, very pleased to see the result. And the important thing here is the connection between the responsibility and the duty of the Security Council, because there's a direct reference to the Security Council adopting a resolution under Chapter 7. And because that is a signal to the rest of the world that you should not be acting on your own here, because the council has a responsibility, because otherwise you would have other states thinking that they could intervene just as they please, and that would violate actually the UN Charter. You have only the right of self-defense, and certainly also collective self-defense. So of course, if a neighboring state is threatening you and there are actions from that state taking against you, you can defend yourself and you can ask others to assist, as they have done from Iraq and in Syria, for example, that others can assist Iraq there. But the main responsibility rests on the Security Council under Article 24 of the UN Charter. And that is the beauty, I would say, of the responsibility to protect resolution. Thank you.
It's a beauty, and it's also the undoing, because by expressly stating that it can only be effective if the council gives authority, you're dooming it to you're making it hostage to the veto, and that's why we're here this morning. The other thing I would say is that, well, we shouldn't get off into another topic. Focusing on this morning's topic, I think there are many, many good reasons why we should start imagining how to move this forward. And what an advantage to have this audience this morning of representatives of states parties to the ICC, who are by definition interested in, committed to, aware of these issues. And so let us devote some time this morning to advocacy with those in the audience, asking you to consider how you and your state might contribute to this process of marshaling support, of explaining these concepts, of inviting others to join, and working towards the day when we can put these issues into a resolution of the General Assembly so that that body can speak for itself as to its position on the legality of the veto in these cases, and a resolution which refers these issues to the court, which has the authority, the respect, the prestige to make a pronouncement which may be advisory, which carries an awful lot of weight and has, as Justice Goldstone has said, the capacity to embarrass those who, in the face of such an opinion, would still insist on arbitrarily casting a veto in a case of compelling humanitarian need.
Justice Goldstone,
anything? Well, I think Ambassador Rock's last remarks make me think about the advisability and possibility of the Assembly of States Parties taking up the question of the veto. I don't think there was one question I read on the Q&A. I don't think it's for the prosecutor to take any steps, for example, with regard to war crimes committed in Syria. But there's no reason why the Assembly of States Party shouldn't. It would be interesting to get a reaction from the United Kingdom and France as the two states parties amongst the P5.
Good.
But this is something, and I really think it's significant that the ambassador from Sierra Leone made the strong remarks he did in opening this discussion.
Good.
May I add to these comments also? I completely support this, and this is why I initially started out with this plea to those who represent the states at the Assembly of States Parties to look at their responsibility for this issue. Now, if they can take it up in the meeting, so much the better. But I think it's very important that things are done in the right manner here and that we proceed along these lines, because it's absolutely necessary. And Sierra Leone, of course, in my view, has a very good record. I never forget my negotiations with Sierra Leone for the special court. They insisted they would have a proper court with independence, and there should be a majority of foreign judges on the court. And as a matter of fact, when they made their first proposal for judges on the court, among the judges was one who came from another country, in addition to those proposed by the Secretary General. So I think Sierra Leone speaks here with some authority. Thank you.
Yes, thank you very much. Actually, for everybody, for the audience, better understanding, one of the questions that was posed was actually whether we could envisage the ICC specifically requesting the Security Council to refer a case. And as Justice GOLDSTONE mentioned, you know, he discussed actually the appropriateness of the specific organ within the ICC that could potentially do that. I think that we have actually almost exhausted our time. I'm looking at Jennifer, and I know I would really very much like her to give us some closing remarks and draw some conclusions from this very enlightening discussion. Jennifer, please.
Oh, thank you. And then maybe the others would have some closing reflections as well. First, in terms of states, I'm already very grateful to have so far the support of Sierra Leone, Costa Rica, and the Netherlands, who also are the three states that sponsored my book launch event this fall at the United Nations. And I'm extremely appreciative of their support and of sponsoring this event today. Of course, as Ambassador Rock said, if this is to progress, you really need a coalition of like-minded states. And I am already heartened that I am endorsed in pursuing this work by a number of very high-level individuals, including those who are on the screen today, as well as Navi Pillay, Andras Vamash-Goldman, David Crane, Judge Christine Vanden Wingert, Zayrad Al-Hussein, Erwin Cutler, and Xavier Jean Kaita and Lloyd Axworthy, as well as, I won't read them out, a list of 14 or so NGOs, including International Center for Transitional Justice, and various others. I guess I will mention World Federalist Movement, as I saw, I know they are here, and OSJI, ICTJ, and Parliamentarians for Global Action, and a number of others. And I'm grateful that you support this, but it's ultimately states that need to do it. And as we're, intriguingly talking about the role of the ASP, and, I know the Syria referral it has passed by, and that has not been able to happen. And that's really meant there won't be, at least in the political reality within which we exist, there won't be a comprehensive look at accountability, and that is really tragic. And recognize some of the ISIL perpetrators are being tried for counterterrorism or fighting for ISIL, and once they're tried, potentially double jeopardy attaches. They can't be tried for genocide, and this is what's happening. So the story, the narrative, the tribunal that you could have had, as in, the Rwanda tribunal looked at things topically. Sierra Leone looked at the three main warring factions. You could have looked at the main perpetrators, the main crime scenes in Syria in a holistic way and brought these cases before a single tribunal. This is what's blocked. It's both ICC referral, and of course, we're not talking a freestanding tribunal. And today we're not even talking very much about Myanmar. Why? Because we acknowledge there would be a veto. And it was urged previously in the panel, other states on the Security Council, they should push these issues. I think the world does not know when there's an actual veto, this makes the news, but the veto threats don't make the news. So why don't we even talk about a Myanmar tribunal? Because note, the ICC only has jurisdiction over cross-border crimes, ones that have gone somewhat also into Bangladesh. And that is the only way the ICC can exercise jurisdiction. That is not the core genocide charges. And although we have the double-I-double-M mechanism to collect this evidence, if it doesn't have a venue, the prosecutions cannot happen. So it is also because of the way that the veto is being used that we're not even talking about a Myanmar tribunal. We're not talking about referral of the situation as a whole. There's so many other situations of the worst atrocity crimes. And I think this discussion shows that the ASP could have a voice on it. The states that support the court are the natural constituents to take these measures up. So those are my concluding thoughts. Thank you.
Thank you very much. Ambassador Corral.
I just thank you for being part of this discussion. It is so important. And I think that those who listen now and who represent their states in the Assembly of States Parties, I hope that they reflect on what has been said here. And let me just close on the note that no effort should be spared in securing the purpose of the United Nations by a generation that had experienced 2 world wars. The conclusion here, to save succeeding generations from the scourge of war. Thank you.
Thank you. Justice Goldstone, if I can give you the floor.
Well, I agree entirely with the general trend of the discussion and some of the, I think, practical suggestions which have come out of it. I would just like to end by thanking Jennifer TRAHAN for her book and the tremendous research and thought that has gone into it, and for pushing this project, and to thank you, Anna Mariam, for so efficiently moderating the panel. It's been a great pleasure to be on it. Thank you very much.
Thank you very much, Ambassador Rock.
Well, just a word to say the same. Thank you so much for those who have organized the panel, to Professor TRAHAN for her brilliant work. I think we can conclude by saying that you've told us what to do and suggested how we can do it, Jennifer. And now let's get to work.
Yes, indeed. So, well, speaking about the moderation, I apologize because it's always very tough to ensure that all the questions are given the right attention. And I'm sure that we have probably some have fallen off the radar, but I tried my best to keep the conversation flowing. Congratulations again to Professor TRAHAN. We have been privileged to see her development thinking and to be close to her during the preparation of this book. It was a great pleasure and a great privilege also for all the colleagues in ICTJ that have benefited tremendously from her reflections. So with that, I wish you all a very good remainder of the day for those of you that are in New York, and a good evening, and all the best for this very dense and important session of the ASP. Thank you again.
Thank you.
Thank you.
Bye-bye.